Hello, this is Matt on the Moon Lambeau channel, and the SEC is withholding crucial evidence in the case that the SEC has brought against Ripple, alleging that Ripple has sold XRP as an unregistered security. There's an 11-page document that was filed by Ripple's legal team. I read the whole thing, and they have a rather compelling case. And I have to tell you, I don't believe that the SEC's team of asshat lawyers, I don't believe for a moment that they believe what they're stating, because they're saying, you'll see here, wait till I'm going to paint a perfectly good picture for you. You'll see what's going on here, but they're claiming that what Ripple is insisting be delivered, this evidence, crucial evidence, they're saying that it's irrelevant. There's no way they could possibly believe this. It is very crucial. It is very important in determining whether or not XRP is a security, and the thought process that the SEC has gone through in determining the legal status of Bitcoin and Ether. So, lots to talk about here. I do want to be clear that I don't have a legal background of any kind, and I am not offering legal advice. I also don't have a financial background, and I'm not offering financial advice, and so you should not buy or sell anything because of anything I say or write. I'm nothing more than an enthusiast who likes to make YouTube videos about Ripple and XRP and crypto-related topics and stories. That is indeed all that it is. And I very much appreciate the support, so thank you for stopping by. So here's a headline from You Today. Ripple asks court to force SEC to produce documents regarding Bitcoin and Ethereum. The lawyers who represent Ripple Labs CEO Brad Garlinghouse and co-founder Chris Larson are asking federal judge Annalisa Torres to compel the U.S. Securities and Exchange Commission to produce documents relevant to its lawsuit against the blockchain company. In a motion filed on March 15th, they claim that the SEC has failed to produce any documents apart from the ones that were selected by the regulator. And Ripple wants the regulator to produce documents regarding Bitcoin and Ethereum, the two largest cryptocurrencies that have been defined as non-securities. And so notably, it asserts that the economic substance of XRP transactions doesn't differ from that of the aforementioned cryptocurrencies, even though the token often faces criticism for its centralization. And obviously the centralization nonsense, it just comes from Bitcoin maximalists. Bitcoin, no Ripple, centralized. That's exactly what they sound like, by the way. In case you haven't heard of Bitcoin maxi troll talk, that's about all you get. They're really just, I tell you what, just unsophisticated, knuckle-dragging, mouth-breathing troglodytes with cashew-sized brains, need help getting their shirts on in the morning, wearing a helmet, wearing Velcro shoes. They don't know what the hell is going on. They just walk around mumbling nonsense. That's what Bitcoin maxi trolls say. But if you look at the facts, obviously, the XRP ledger, the centralization, what node is the central point of failure? What entity has special permissions over the XRP ledger? Well, there is none, And if people like to point to the Bitcoin maxi trolls, they'll just lie or just say stuff that they believe is true because they haven't done any research. Whatever it is, either way, it's bad. But Ripple only controls, 16% of validators on the network? So it's completely bugged. Ripple doesn't have any special permissions anyway, though. So, also, if you haven't gone to Crypto Law, you got to check out this. This is attorney John Deaton's website. He's posting all sorts of awesome stuff, and this is where I got the link for this. He's on Twitter. It's at Crypto Law US, and if you want to go to the website, it's crypto-law.us. I encourage you to take a look-see here. Now, since this is really long, again, 11 pages, not going to go through the whole thing, but I did run through find some spots that in here that I think you're really going to find rather fascinating. And I am going to start at the top, though. So check this out. Again, this was just filed. We write, Dear Judge Netburn, we write on behalf of defendants Ripple Labs, Inc., Bradley Garlinghouse, and Christian Larson, pursuant to Part 2C of the court's individual practices, to request a local Rule 37.2 conference. Whatever the hell that means, it doesn't matter. It's gibberish to me. But most of this is written that in such a way that a person without any sort of legal background can easily understand it. Now, after 3 lengthy video conferences and an exchange of letters, defendants and the Securities and Exchange Commission have reached an impasse regarding the SEC's refusal to search for and produce information related to the core issues of this litigation, whether sales of XRP were unregistered securities offerings, whether Mr. Garlinghouse and Mr. Larson, the individual defendants, knowingly or recklessly failed to recognize them as such, and whether Ripple had fair notice that XRP sales required registration. And mind you, and I mentioned this in just my last video, and not just my last video, I've been saying the last few days here. The SEC, in trying to smack down the legal filings that Attorney John Deaton has put forth, and they've cited that one of the reasons, a primary reason, is because XRP today is not technically a security. Think about that. So as recent as like a week and a half ago, the SEC saying that they're trying to get rid of Attorney John Deaton's legal filings because they say that it's not, XRP, not today, a security. Just smack it down. But somehow, Brad Garlinghouse and Ripple and Chris Larson, they were supposed to know like 7 freaking years ago that what they were doing was illegal. Again, like a week and a half ago, these asshats over at the SEC didn't even, it's the hypocrisy, it knows no bounds here, right? Anyway, but specifically, the SEC has refused to search for and produce a single document concerning Bitcoin or Ether, 2 virtual currencies that are closely analogous to XRP, internal communications of any sort, even where they reveal the markets and the SEC's own prolonged uncertainty over whether XRP was a security, and any documents from 10 of the 19 custodian defendants proposed a limitation that lacks any basis other than the SEC's refusal to search for and produce documents in categories 1 and 2. And the requested discovery easily meets the broad standard of relevance under the under Federal Rule of Civil Procedure, and they cite what that is. And despite multiple opportunities to do so, the SEC has failed to substantiate any privilege or burden claim that would excuse the SEC from searching for it. So if I could just kind of translate some of this, do you see what these asshats at the SEC are doing? They know that this information would not be good for their case. And so they're not going to turn over this crucial evidence unless they're forced to. And they better be forced to, or else this is just going to be like just an absolute miscarriage of justice, in my opinion. Like it would be terrible, because this is really important to Ripple, making the points that they've already articulated, a lot of their points, but in terms of proving the relevance of it, and just this idea that, of course, it's absurd that to have expected Ripple and Brad Garlinghouse and Chris Larson to have believed that XRP was 7-8 years ago a security. It's just completely nonsensical. And so then you're right here. Here we go. The court should therefore compel the SEC to conduct a reasonable search for and produce all non-privileged documents responsive to the disputed requests. And so for situations like this, assuming that they are compelled by the court to do so, how do you know that they're actually handing everything over? I don't know how this works. Is there a third party that can audit them? Are we on the honor system here? Because I sure as hell don't trust them to turn over everything. Now, hopefully, if they're compelled to do so, one would think that there would be some sort of legal implication if you don't hand over everything. So should something ever come out, or there's a whistleblower and this or that, hopefully that would be enough to make them feel compelled to like, okay, we better actually do this because the court says we must. I would hope. I don't have a legal background though, so I don't know how this works. So it's a question and perhaps a small concern of mine, because again, I just do not trust this team of asshat lawyers. I just simply do not. And then this continues here. Whether the market and the SEC itself considered XRP sales to be securities offerings are central questions in this litigation. So this gets to why this is so damn important. On December 22nd, 2020, as the SEC's chair and its directors from the prior administration were walking out the door, the SEC filed this case alleging that sales over the last 8 years of XRP, the third largest digital asset in the world by market value, had been a massive unregistered securities offering in violation of Section 5 of the Securities Act of 1933. The SEC does not contend that Ripple or the individual defendants made any effort to conceal their activities, nor could they. XRP is a well-known and widely used digital asset with global trading volume since inception of between $700 billion and $1 trillion with a T. That's a ton. The SEC's complaint cites liberally from public statements that Ripple made to the market regarding its activities, and in particular the nature, use case, and sale of XRP. For almost a decade, the SEC watched as XRP grew and developed, all the while issuing no formal guidance that its sales may be illegal. The SEC did, however, announce that sales of two similar digital assets, Bitcoin and Ether, were not securities offerings. Moreover, in 2015, the Department of Justice and FinCEN entered into a settlement agreement with Ripple that determined XRP to be a virtual currency, again, like Bitcoin and Ether. As a result, Ripple's subsidiary XRP2 LLC was subject to anti-money laundering requirements as a money service business. As the SEC well knows, XRP has been listed on more than 200 virtual currency exchanges. Prior to listing XRP on their platforms, these independent businesses must have concluded that XRP was not a security, likely with the guidance of sophisticated securities counsel. None of these platforms were registered with the SEC as securities exchanges. So think about that. And it's just amazing, just this idea that Ripple was allowed to do this for the better part of a decade. And so that means since the SEC was aware of all this, they allowed, if they really believed what they were saying, and I don't think they do. I don't think they believe their own position. It's just a power grab, it looks like to me. But if they did, that would mean that for the better part of a decade, since they allowed it to go unchecked, they allowed harm to investors because purely through their inaction, if they actually believe what they're saying, they caused harm to investors like you and me through their inaction. But you don't think they actually believe that nonsense, do you? It's a power grab. That's absolutely, it's a power grab and a money grab. They want to get money from Ripple. They want to find them. But the SEC now contends that under a straightforward application of a well-settled legal test, the Supreme Court's 75-year-old precedent, and they're talking about the Howey test there, defendant sales of XRP are and always have been an unregistered securities offering. See letter from Jorge, am I saying that? Tenrero? I'm sorry, I'm butchering the name, to Honorable Annalisa Torres, in characterizing this as the single issue to be decided and a question of strict liability. At one, the SEC ignores at least three questions central to this case. At first, I'll just be brief on the three. First, the Howey test is not a sterile exercise to be conducted in a vacuum, but rather requires the court to consider, among other factors, what character the instrument is given in commerce by the terms of the offer, the plan of the distribution, and the economic inducements held out to the prospect. The court will conduct an objective inquiry into the character of the instrument or transaction offer based on what the purchasers were led to expect. And as explained below, the SEC itself was a central player in the market-wide discussion, analysis, and practice about whether and under what circumstances sales of digital assets could be securities offerings. In other words, the SEC itself helped shape the character of XRP and other digital assets in commerce and what market participants could expect. Exactly. And so this goes back to, in my opinion, they do talk about this too. It's one of the things they bring up. It's just this idea of fair notice. To me, it's kind of similar. Like, so they're listing it as a separate point here, but to me, in a way, it's almost one and the same. But the second point they bring up here is the SEC chose to charge the individual defendants with aiding and abetting Ripple's violations of Section 5. To prove this, the SEC must show that the individual defendants knew or recklessly disregarded that they were associating themselves with something improper and nonetheless substantially assisted Ripple in committing that violation. The SEC has thus chosen to put an issue not only whether XRP sales were securities offerings, but whether the individual defendants knowingly or recklessly failed to recognize them as such. Yes, and so that's that term that we've been using here, scienter. It's a legal term, meaning that it's not just enough to have done the action. You have to, again, either been how'd they word it, willfully, reckless disregard, or you had to have known that what you were doing absolutely was illegal. And then the third point was that Ripple has pleaded a well-founded defense that it was deprived of fair notice that XRP sales required registration by the SEC's own conduct, including its public announcements that similar digital currency sales were not securities offerings, as well as the course of dealing over the 8 years preceding this action. And so, set aside legally what's a good argument, what isn't. Just use your own reasonably intelligent human mind. If you're Brad Garlinghouse and you're Chris Larson or anybody at Ripple, and you look at how the SEC has decided to treat, let's just say Ether specifically, because there's an entity there that's back, there's the Ethereum Foundation, but I understand Bitcoin a little bit different. And that there's Satoshi Nakamoto, the creator of Bitcoin, but who the hell is that, right? So you can't go knock on Satoshi Nakamoto's door here, but you could go to the Ethereum Foundation, you could go to Ripple Labs, right? And so if you're Brad Garlinghouse or Chris Larson or anyone at Ripple, and you see that just the way in which XRP or Ether gets out into the wild, if you see that it's not that different, and the way that they're justifying the position of Ether as a non-security, so much of that lines up with what's happened with XRP2. How could you ever reasonably, if you're being a genuine person, how could you ever reasonably make the argument that you believe Brad and Chris and Ripple knew that what they were doing was illegal? See, it doesn't pass the smell test. I don't think the SEC believes what they're actually saying here. I really don't. I just think they're making up a bunch of crap because, again, it's a power grab and a money grab. And then there's this part. I scroll down a little bit. Okay, evidence concerning the SEC's own discussions and views about whether XRP, Bitcoin, and Ethers are securities is relevant. Oh, yes. So this is the crucial evidence that is absolutely missing that the SEC does not want to hand over, because I think they got some skeletons in the closet. I bet they do. The SEC is improperly withholding relevant, potentially exculpatory evidence. In this case, the SEC is not a passive bystander or detached regulator pursuing a run-of-the-mill case against someone who violated established law or regulations. During the relevant period, the SEC itself was a central player in market-wide discussion, analysis, and practice about whether and under what circumstances sales of digital assets could be securities offerings. Because documents and communications, whether external or internal, regarding how XRP and two similar assets, Bitcoin and Ether, were perceived and treated by market participants and the SEC, bear on, or reasonably could lead to other matters that could bear on, several issues that are, or may be in the case, relevant, frankly. Of course this is relevant. Why would the logic utilized to determine whether or not Ether is a security, how could that not be relevant in their process for determining what if XRP is sold as a security? Because if they have this line of thought, if they have this logic they believe in that indicates Ether's not a security, well, clearly, if they weren't being completely inept, don't you think they would have compared it to Ether? Don't you think there would be internal conversation on this topic? I sure as hell do. Of course there is. How could there not be? I mean, yeah, because you're talking about, otherwise it's just an extreme level of incompetency, and you could argue that's what is going on here, that they're incompetent. I think it's more so that they're just being little rat bastards. Like that's what these asshats are doing. Just this army of bunch of asshats just marching forward. That's the sound of the marching. Asshat march, asshat march. That's what they're doing here. And I don't think it's purely incompetence. I mean, there is some incompetence because they've kind of highlighted a bunch of hypocrisy. So yeah, you could argue a bit of incompetence, but no, I think it's a power grab and a money grab. That's absolutely what it looks like to me. And then Ripple's team writes here, the SEC cannot reasonably dispute the relevance of these categories or documents, nor does the SEC deny that it is in possession of such evidence. The public records reflect that at least by 2017, the SEC was considering and giving guidance on whether and how digital assets could be classified as securities. For example, in July 2017, the SEC issued a report of investigation concluding that DAO tokens were securities. Yet the SEC remained silent in the face of direct inquiries on the status of XRP and allowed market participants to proceed with sales and offers. Exactly, going to the point that I made earlier, which is that their inaction allowed investor harm. If they believe what they're stating here, their inaction caused investor harm. It's not reasonable to take the better part of it, almost an entire decade, frankly, to decide you want to take action. That is not reasonable. Not even close. And so in 2018, the SEC's Director of Corporate Finance publicly stated that Bitcoin and Ether were not securities, and its Strategic Hub for Innovation in Financial Technology issued a 38-factor test in 2019 that could not reasonably be read to suggest that XRP should be regulated as a security. Commissioner Peirce compared, that's Hester Peirce we're talking about, compared the SEC's framework for investment contract to a Jackson Pollock painting, splashing lots of factors on the canvas without any clear message. Indeed. Yeah, Hester Peirce has been rather critical of her employer, the SEC. And so it's just interesting to see that her own words now are being used to defend Ripple and Brad Garlinghouse and Chris Larsen. Because it's true. I mean, that wasn't her intent when she stated that. That was back in 2019 when she said that, May 9th, 2019. But it's an acknowledgement from somebody of notable importance in the SEC that there is not clarity here. So if there's not clarity and somebody at the SEC then was saying it, how the hell do you expect Brad Garlinghouse and Ripple and Chris Larsen to think that what they're doing is wrong? It doesn't make any damn sense. Even inside the SEC, they can't agree with one another. So it's kind of ridiculous, is it not? So those were the most important parts that I wanted to highlight here. It'll be interesting to see how this, what comes of this. I'll continue to provide updates here. But I just can't imagine that somebody with a level head that isn't biased wouldn't rule in favor of Ripple's position here, right? It cannot happen. And so the damn little asshat lawyers at the SEC, as far as I'm concerned, they can freaking suck it. Eggplant emoji. Seriously. Okay, I'm just saying, but I will wrap up there. I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.